The criminal activities of NICOLINI law firm continued in 2020. Please feel free to pause and read. It was now NICOLINI law's turn to complete its deception. Ryan Naimark and Courtney Madison, 2019 to 2022. September 2020 continued. Cancellation of the examination for discovery September 29, 2020 without my consent. The case wasn't mine. It belongs to NICOLINI law, so they can do anything. And they can do anything and go against their contract because they know the system would back them. They knew that. And the thing about it, it only makes sense I report them because nothing would have been done. I reported the doctors to the colleges and nothing was done. So it was pointless for me to do otherwise, right? But they breached their contract, okay? And I will prove it to you. The breach of contract. This was actually extracted from their contract. No. Yes, from their contract. September 29, 2020, breach of contract. The examination for discovery was cancelled without my consent. NICOLINI law cancelled without my consent the examination for discovery, which was scheduled for September 29, 2020. A year prior, they had taken the examination for discovery from Benjamin Law, which was scheduled for August 16, 2019. It was cancelled after I was coerced to move to their firm. NICOLINI law did nothing for my cases for over a year, never met with me once to discuss my cases, gave several reasons to speak with the defense lawyers, etc. Deception. All right, I have this information on the next slide for a better view. Okay, you can read my doodles here. Okay, obtained from contract signed with NICOLINI law on July 26, 2019, breached. It says here, client to make all critical decisions. You see that? Did I get it wrong? Clients to make all critical decisions, firm to make non-critical decisions. Okay, during various critical times throughout the claims process, such as hearings, critical hearings, mediations, critical times, pre-trial conferences, critical times, without prejudice, settlement meetings, etc. The firm will explain the costs, the risks, and expenses of continuing with the claims, and the firm will provide their best assessment of the case based on the facts existing at the time. All right, the firm will not, however, make the decisions for the client in relation to resolution, and the client hereby acknowledges that it will make all critical decisions with respect to resolving their own claims. The firm shall, however, remain the decision maker when it comes to non-critical decisions, such as non-critical decision, requesting or agreeing to adjournments, non-critical, bringing or responding to motions, non-critical, selecting experts, non-critical. So you see, critical times, right, such as hearings and so forth, right? So if I did not respond to, say, cancel, should this lawyer cancelled? And I did say no from the beginning. Please feel free to review. Thank you. One of several breaches of contract, and as you can see, that's the contract there. Okay, and it's there. All right. Please feel free to review. That's it. That's what I got. Please feel free to read if you wish. Okay, thank you. October 2020. On September 29, 2020, Courtney Madison canceled the examination for discovery without my consent. It was the first time I heard of an affidavit. First time, eh? During our conversation. Imagine how they wanted me to go to a discovery and didn't know about affidavit. Can you imagine? During our conversation on September 28, 2020, NICOLINI law, I guess that was a slip of the tongue. NICOLINI law had no intention to have the examination for discovery since they were not prepared. I was not prepared by NICOLINI law. I requested a review of the affidavit. I was unable to save copies of the contents of the affidavit since the files disappeared within 2 weeks. I did not know that the files would have disappeared, and as a matter of fact, I did not understand it at all. Right? I said here on Tuesday, October 6, 2019. Oh no, this was from Samantha, because Courtney told her to forward the affidavit to me, right? And I enlarged it for you, right? On Tuesday, October 6, 2020 at 10:21 a.m., Samantha Bray said, "Hi, Delane, I hope you are doing well. Courtney asked that I forward you a copy of the affidavit of documents we served on your behalf." Can you, as I said, I have nothing to do with any of my cases, okay? They serve the documents on my behalf, so you can review the documents, and also you advise that you may have some additional documents. Oh no, I would not be given those documents. No, I have sent you a copy of the link via OneDrive. The password to access the documents is Grant at the time. Yeah, if you have any problem accessing the document, let me know, okay? And okay, I went in. I was able to go in. Okay, this is a document, and I was able to go in. On September 28, 2020, the lawyer stated there would be no mediation. Would be mediation. Say would be the mediation. Did not hear from lawyer. Okay. From Delane, to Samantha, I said to Samantha, "Hi Samantha, please be advised that I do not understand the document that was opened with the Ontario Superior Court of Justice. Therefore, I have not placed my signature for consent." Yeah, the document was so confusing. It was so confusing. I know me. I tried to understand things, but I just didn't understand, and I didn't know that it would have been taken away. After a few days or so, it was taken away. The lawyer and I have never met in person to discuss my case, but I sent emails and spoke on phone briefly for her to get an understanding of the reasons I was suing the entities. This lawyer did her own thing. Yeah, because what I'm seeing is so confusing. Okay, then Samantha Bray on October 9th, right, responded, and she said, "Hi Delane, that is fine. A very brief explanation is that the affidavit of documents, this details and lists all relevant." So I'm telling you, the take out, and I will prove it to you later on. All right, take out all relevant documents for clients' claims that are in a party's possession or control. It will have to be signed eventually, but it is not important at this time. Courtney will discuss the affidavit of documents with you further and expand on the explanation for the next examination for discovery. Okay, before the review, thank you. Okay, month of October 2020, I had not heard from lawyer Courtney Madison or anyone else from Naimark Law. Email received at 2:19 p.m. on September 28, 2020. As you can see, she did say that I confirm on September 28th, right, 2020 at 2:19. I confirm I have recommended to you that we engage in settlement discussions and adjourn your discovery by 1 month. Okay. 2. Here again, month of October 2020. I have not heard from lawyer Courtney Madison or anyone else from Naimark Law. Email received at 3:19 p.m. on September 28, 2020. As you can see here, Monday, September 28, 2020 at 3:90 p.m. And what did Courtney said? Courtney Madison, she said again, "I would highly recommend that you accept my advice to put over the discovery 1 month and discuss on negotiating a settlement in the interim." That means that they are planning on doing a mediation. All right, 1 month. How could Naimark Law force me into mediation to negotiate settlement when I have never met with this lawyer once to discuss my cases? I don't even know the details of my cases and the amount being sued, especially since this law firm said that they take out and whatever. I do not know what they're planning. I do not know what they were going to present. We have to be on the same page. We weren't. It's obvious that we weren't, right? But 1 month of October started, and I didn't hear from this lawyer. As we go along, you'll realize that. Okay, feel free to review. Thank you.